On the 2nd of February of 2022, judgment was given in the case of Cojanu and Essex Partnership University NHS Trust, which is reported at 2022, 4 Weeklies 33. The case underlines the principle that all are equal before the law, and that convicted criminals, even those who are convicted of the gravest of crimes, and then lie about that fact in later civil proceedings, will not thereby be shut out from their remedies before the civil courts. The facts were that following an incident in which a man called Dorinel Cojanu had attacked his wife with a knife, he was remanded to HMP Bedford with deep cuts to his right ring finger and a little finger. The NHS Trust, which was supplying medical services to the prison, had prearranged a repair operation but decided to cancel it on the grounds that treatment was available more locally and that a security risk arose when prisoners were given dates for their appointments in advance. Due to a delay in arranging the local surgery, Mr. Cojanu lost the opportunity to have his cut finger tendons repaired, and he then brought a personal injury claim based on what was said to be clinical negligence by the defendant, NHS Trust, while he'd been on remand. He claimed that he would have made a full recovery if he'd received surgery within 10 days of suffering the original injury, but that the Trust had negligently delayed his treatment, and he placed reliance on Prison Service Order PSO 3200, which requires that prisoners are provided with an equivalent health service to that available to members of the public. At trial, the recorder found that the Trust had been negligent in failing to fax a referral letter to the local hospital, thereby delaying the claimant's treatment. But the recorder then went on to consider quantum and defences, including the statutory defence of fundamental dishonesty under Section 57 of the Criminal Justice and Courts Act of 2015. On that latter issue, the recorder found that the claimant had been fundamentally dishonest in various ways, including making no mention in his claim of the real cause of his injuries, stating in his witness statement that they resulted from his wife attacking him with a knife, and never mentioning that by the time he brought the claim, he'd been convicted of the attempted murder of his wife. The recorder also found that the quantum of the claim had been dishonestly inflated, and so he dismissed the claim. On appeal to the Queen's Bench Division of the High Court, Mr. Justice Ritchie held as follows. Firstly, under Section 57 of the 2015 Act, the defendant to the claim had to establish to the civil standard that there had been dishonesty on the part of the claimant in relation to a matter fundamental to that claim. Dishonesty in relation to something incidental or collateral to the claim was not fundamental for these purposes. Secondly, the test of dishonesty for these purposes in this statutory defence was as explained in Ivey and Genting casinos, Howlett and Davies, and London Organising Committee of the Olympic and Paralympic Games, and Sinfield. Thirdly, here, in order to establish his claim, the claimant did not have to prove what caused the original cut. The mechanism of how the injuries had been sustained had no relevance to the clinical negligence action and was merely incidental or collateral to the claim. The claimant's dishonesty about the background only impinged on his credibility, but liability here ultimately depended on expert evidence, not on the claimant's own testimony, nor did his dishonesty impact on the issue of quantum. Fourthly, all citizens, including those with criminal convictions, are equally entitled to bring civil actions before the courts. Put another way, Section 57 was not a, quotes, credibility filter, barring such people from bringing a claim. The NHS could not and did not turn away criminals or any other classes of person, or discriminate against patients on any ground, and the same applied to the civil law. Fifth, accordingly, the claimant was not deprived of his right to sue just because he'd been convicted of the attempted murder of his wife and had then lied about it. The primary purpose of Section 57 was to stamp out fraudulent and dishonest claims, not to bar from the civil law criminals who were either unrepentant or in denial. And so, for all those reasons, the appeal was allowed and judgment was entered for the claimant.